If a criminal defense lawyer fails to raise the issue of police improperly executing a search warrant, is that ineffective assistance of counsel that can reverse the conviction? To find out, you have to read People versus Hayward, but it's 13 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Hayward. The citation for this case is 2024 New York Slip Opinion 05243, published by the New York Court of Appeals on October 24th of 2024. The issue in this case is whether a single instance of alleged ineffective assistance of counsel is appropriate with respect to a failure to request suppression of a no-knock search warrant violation. To understand and appreciate the context of this case, the first thing you have to know is that there's two kinds of search warrants. There are two main kinds of search warrants. There are search warrants. The general search warrant is one where the police have to knock on a door, announce themselves, and can then enter the premises after giving the occupants a reasonable time to open the door and look for the items to be seized and the locations to be searched. That's a normal search warrant. Then there are no-knock warrants, and no-knock warrants are a little different to the extent that the execution of a no-knock warrant is different. The police don't have to first announce their presence. They can do it on different hours. They can do it basically. The reason why they could do this without knocking and announcing who they are is for fear that the occupants with the contraband that's sought to be obtained are either armed and dangerous or are going to throw out the drugs in the toilet or down the bathtub, that kind of thing. So it's to preserve the items that are going to be sought by the search warrant itself. And the last thing you have to know is that there's a federal case called Hudson versus Michigan out of the United States Supreme Court from 2006 that holds that a violation of a knock and announce rule by police with a search warrant does not require the application of the exclusionary rule. So if the police go with a search warrant that says they have to knock and announce and they fail to do that, under the federal law, that does not require suppression of the evidence that's recovered. What are the facts in this case? The facts are, and the last thing to know is that New York doesn't have anything like that. There's no case law in New York about requiring suppression of a failure to knock and announce. So what are the facts here? The facts are the defendant and other people were in an apartment building, with heroin and cocaine, allegedly. The police get a regular search warrant that requires them to knock and announce before entry. The police then entered with the search warrant, and the defendant, who was represented during the course of the case of possession of heroin and cocaine, he was represented by a lawyer who did not specifically challenge the warrant's execution. He challenged the warrant as being inaccurate or unreliable, but never made a claim or an appeal based upon or a claim during the proceeding that the warrant itself was executed improperly, that the police failed to announce themselves. The defendant was found guilty, and on appeal, the defendant claimed that his lawyer was ineffective. He made an ineffective assistance of counsel claim, said my lawyer was deficient. And the basis of that was that the lawyer failed to make that claim that the police improperly executed the warrant by failing to announce themselves. On appeal, the appellate division rejected that claim, and it goes to the Court of Appeals. And here, the Court of Appeals says, yes, listen, for ineffective assistance of counsel claims, we do recognize that a single claim, a single deficiency, can be enough to ground an ineffective assistance of counsel claim. But it has to be egregious and prejudicial, so egregious and prejudicial as to deprive the defendant of the constitutional right to effective representation. To rise to that level, the omission must typically involve an issue that's so clear-cut and dispositive that no reasonable defense counsel would have failed to assert it. And it must be evident that the decision to forego that claim or defense could not have been grounded in a reasonable, legitimate trial strategy. So it's not effective. That claim is not effective when it's a novel question that's not been addressed, or when there's no clear-cut appellate authority saying that the defendant would win or that the defendant's right. So here they apply that analysis and they say the federal rule from 2006 said this is not an exclusionary rule subject, and there's no New York case law saying it is. So they're saying it's not dispositive. It's not a clear-cut case that it's so prejudicial and egregious that a lawyer would have to have some kind of legitimate trial strategy to avoid it. It's not that kind of a case. And therefore, the claim for ineffective assistance of counsel fails. And that's the case of People versus Hayward. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.